Okay, so in terms of types of intellectual property that exist, there are many, many types, and there are more types than are listed on this screen. The first one, and because today's talk is aimed at people who are bringing their business online, the first and probably most important type of IP right that you might want to know about is copyright. Copyright, I'll cover in more detail later on, but essentially copyright covers any sort of expressive artwork or writing or stage performance or anything that involves the expression of your own ideas in some sort of form. So for businesses, that could be, for example, instruction manuals or brochures or advertising jingles, or it could be a video that you upload to YouTube. Anything like that could potentially be covered by copyright. The next one, as someone taking your business online, you need to know about is probably trademarks. So trademarks are effectively the branding of your business, except a trademark is a bit more specific than a brand. And I'll go into more depth on that later on. But a trademark is essentially a way to identify your business. So if I say, for example, DBS, it immediately tells you which business I'm talking about, and you can identify that business and everyone knows automatically who you're dealing with. And the reason that trademarks become important is because if someone else were to pretend that they were DBS, you would be confused. So if someone texted you and said, "Hi, I'm Jack from DBS, please tell me your phone number, please tell me your bank details or something," you might be confused into giving them that detail, and then that's not DBS, and you would be confused and you could be scammed and all this sort of stuff. So trademarks protect that sort of aspect, and more commercially it protects consumer confusion, so you don't walk into a store and accidentally buy the wrong type of coffee when you were looking for one type instead of another. Also very important is things like know-how and confidential information. So you have, after starting up your business and developing it and finding out who you're working with, who you're selling to, who the stakeholders are, how you do something efficiently, all this information becomes valuable information that you don't necessarily want to share with your competitors, because if your competitors can get that information for free, then it gives them a leg up, and you want to reserve that for your own business. So that would be protected under the law of confidential information. Less relevant to taking your business online, a couple of rights that are vaguely similar are patents and designs. Now, patents cover inventions. So if you invent a new way to filter coffee, if you invent, some sort of automatic anything, I don't know, think of whatever you want. If you invent something, you can potentially get a patent, provided that your invention is both new and it's not obvious to someone who would be working in that field. We're not really going to be talking about patents much today. I think Meryl might be mentioning it a little bit in her slides, but really the focus of today is on copyright and trademarks. The final one I want to mention is design rights, which may or may not be relevant to your business or your activities, depending on what you do. Design rights cover the visual aspects of a product. So patents cover the functional aspects, so why it's an invention and why it's useful to someone. Designs cover the visual aspects, so the way that something looks. So when you look at, for example, a Nintendo Switch, it's designed in a certain way, and that design could potentially be protected as a registered design under Singapore's law. Okay, I mentioned there are many other types of IP in more specialist areas, but today we're really going to be focusing on copyright and trademarks. Okay, so to further categorize these types of IP rights, I would divide them up into two kinds. One of these kinds is automatically protected under the law. So, for example, if you are a high school student and you write down an essay about your family, so maybe you have an interview with your grandmother, your grand tells you some stories about when she was a child, and then you write that down in the form of an essay to be submitted to your school. The moment that you write down the words on the piece of paper or on your computer, the moment that you hit save for that file, copyright is created at that point. You don't need to do anything else at that point. You don't need to file anything with IPOS. You don't need to register on any website. You don't need to stamp it and sign it, and you don't need to affix any additional symbols. So you don't need the C symbol, the little circle with the C inside it. You don't need to do anything further. That's it. So once you've created that file, you are the owner of the copyright in it. And the consequences that follow from that, I think Meryl will be covering in her presentation. Confidential information also requires nothing from you other than perhaps you might want to protect it by entering into non-disclosure obligations if you're going to tell someone else that information. So anything that is private information, you can simply keep and use, and you can protect it against people who attempt to use it without your permission. Okay, so that's the automatic types of rights that exist. There are some other automatic rights, but I'm not going to confuse you by discussing those at this point. We'll keep it quite basic today. The other category of rights that I want to cover are registrable IP rights. And what I mean by registrable is that in order to get protection under the law for these types of rights, you need to file some sort of application. So in Singapore, that application is filed with IPOS. In other countries, the IP office is called lots of different names, but you basically in every country have to file for protection for these rights. So if you want to register a trademark, you have to file a form TM4 with IPOS. If you want to file a patent, you have to file patent form 1, and you go through a process. And at the end of that process, you get a registration certificate that has your name on it, tells you what you own, and you can show that to the world and say, hey, I am the owner of this trademark, I am the owner of this patent, and therefore I have these rights. So there are upsides and downsides to both of these things. Automatic rights are great because they are cheap, you don't have to do anything. But the downside is it can be a bit difficult sometimes for non-IP specialists to identify what information is protected by copyright and what information is protected by the law of confidential information. On the other hand, registrable rights, well, they do cost a little bit of money to obtain, because when you file trademark form 4, you do need to pay a fee to have your trademark registered, and you need to pay a fee to have it renewed after 10 years. But on the upside, it gives you a very clearly identifiable certificate at the end of the day that says, I am the owner of this thing right here. This is my right, and I know that I have this right in my pocket, and therefore you can go and do things with that that you might not be confident doing with an automatically protected right. So there's kind of balances to both. But this is the system we have in Singapore, and pretty much the same system exists across the world. The only further distinction I would make is that for registrable rights in general, you need to file in every country that you are interested in protecting that IP right in. So if you obtain a trademark in Singapore, it doesn't prevent someone in Malaysia from using that same trademark. So if you wanted to do business in Singapore and Malaysia, you should file a trademark in both countries, not just Singapore, because just filing here will not protect you overseas. Whereas for copyright and confidential information, generally, as a result of international treaties and other types of law that exist, generally, if you create a piece of copyright work in Singapore, you can enforce that against people in other countries around the world. So if someone in the UK, for example, decides to make a copy of your book or your novel, you can then go and sue that person in the UK courts and say, hey, I'm the owner of copyright. I'm from Singapore. I created it in Singapore. This person has copied it, and therefore I want some sort of action. I want some sort of outcome. Okay, so generally registrable rights, you need to file in every country that you're interested in. Generally automatic rights, you don't need to do anything further. They just automatically exist.